You're doing great.
The bottom of page 8, I don't know how to say that.
You are Arthur Mukes. Mr. Mukes, you're charged with resisting arrest, facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. A law enforcement officer was dispatched to a disturbance call on April 19th, 2025 in Harris County, Texas. The officer observed the defendant to be outside of the residence with what appeared to be an injured hand. The defendant stated he injured his hand while punching a wall when he was in an argument with his wife. The defendant stated that he had been drinking Crown and requested medical attention to the scene. The officer attempted to make contact with the female at the residence who refused to open the door. She only stated that the defendant should not be there at the residence and that she was in fear of the defendant. The defendant advised that he would leave the location and return at a later time.
Stop right here. You can already see the warning signs stacking up fast. Self-inflicted injury, alcohol in the mix, a domestic argument boiling over. From a legal standpoint, the officer now has full probable cause to lock in for both public safety and potential assault. So here's the real question for you watching. If you were the responding officer, what move are you making next?
Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. The officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as the officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, the officers attempted to place the defendant in custody for public intoxication. The defendant became actively resistant and pulled away from officers while being escorted to the vehicle. The defendant told the officer, quote, "I'm coming for you," multiple times as he refused transport. The assistance of 4 officers was required to place the defendant in a patrol vehicle. The officer notes that the defendant actively resisted for 7 minutes and 13 seconds.
Mr. Mukes, I'm going to find that there's probable cause to go forward. Now's not the time. I know you're itching to say something, but look, I've got a bunch of prosecutors here. I don't want you to say something that hurts your case. Stop. Resist all attempts. If you want, I can give you a lawyer today, and you can give your side to the lawyer. Okay? But right now, don't. You're only hurting yourself more when you think you're helping. Don't. I'm trying to help you here, Mr. Mukes. The only condition I'm placing on you now, you're not allowed to consume alcohol. Do you understand? If I find that you're using alcohol or illegal drugs, I will put you in jail. Just don't use. Okay? Do we know if she wants to have contact with him?
Judge, the offense date was on the 19th. We have not been able to reach out with the complaining witness yet.
So let's do this. I'm going to have them reach out. I want to know if she wants to have contact with you. If she's okay with it, then I'm going to allow it. Okay? Just don't. So we're going to try to do work on our side or their side to see if they can reach out to her to see if she's okay with contact with you. So let me see.
Morales Vega?
Okay. So, hey, do you mind reaching out to the MAC for Mr. Mukes? I'm going to get you a lawyer here for you soon. I'm going to have you sign a reset with Victoria. We're going to have you take a seat in the jury box. Just look. Just don't. That's all I'm asking you to do, man. Okay?
I was the victim here, and
I know there are two sides. Mr. Mukes,
I'm the one who called them for help, and they locked me up and violated my rights.
hey, Mr. Mukes, there will be video. We will take a look and we'll see because the evidence is going to point to whose side's correct. I don't know. I wasn't there. Stop. Stop. Don't. Please. Good morning, Mr. Ramirez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk-in turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained and the defendant's blood was drawn.
Yeah, may I respond?
Please.
Okay, first of all, Judge, the reason, it's not on there for some reason, but the reason, he told the officer he can't do it because he had surgery to his back and to his knee. He can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I mean, I was actually thinking about that as well. All you have is an odor of alcohol.
And
Anything, there's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? The odor alone is insufficient.
No, Judge, he was coming from a tattoo shop and the police officer asked him, is he alcohol because of the tattoo?
Is he what?
He just had a tattoo put on. That's the odor of alcohol.
Like, come on, man.
I'm just saying. I mean, that the officer actually asked him that question.
What, the little alcohol that you put on your skin, you tell me that?
I don't know how it works, Judge. I've never had a
You're
tattoo.
killing me. You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of an alcoholic beverage emanating from the defendant's breath as he spoke.
Yeah.
That's
That it?
all we have before we initiated the standardized post-mortem test.
Okay, that's not enough. All right, I'm going to find no probable cause in your case, Mr. Mears. You know,
So
we have enough death on our streets now. You know, $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Thanks, Frank. You are Mark Ramirez. Mr. Ramirez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 18th, 2025, in Harris County, Texas, an officer observed a motor vehicle stopped in the right lane of traffic with its hazards on. The officer approached the motor vehicle and observed the defendant to be asleep in the driver's seat. The officer parked his motor vehicle in front of the defendant's vehicle and attempted to wake the defendant up. Once the defendant was awoken, he allowed his motor vehicle to roll forward and strike the officer's vehicle. The defendant then turned the vehicle off, but failed to put it in park, leading the motor vehicle to roll backwards and strike the other officer's motor vehicle that was on scene behind the defendant's motor vehicle. Once the defendant exited the vehicle, he became uncooperative and was required to be detained by the officers. The defendant would not answer any questions and kept saying, "Oh yeah," over and over. The officer observed a strong odor of alcoholic beverage emitting from the defendant. The defendant declined to participate in standard field sobriety tests initially. Once the defendant was transferred to jail, the defendant stated that he wanted to perform the standard field sobriety tests. when asked to perform them again. The defendant was read Miranda warnings and stated that he wanted to speak to the officer. The defendant then stated that he had a 12-pack of beer since he had gotten off of work. The defendant stated he did not know what time it was and what time he stopped drinking. The officer observed the defendant to have bloodshot eyes and slightly slurred speech. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The DIC was read, and the defendant consented to providing a blood sample.
Mr. Ramirez, I'm going to find that there's sufficient probable cause to go forward with the case. If you have a problem with drugs or alcohol, now is the opportunity that you're going to get to address it. If you don't, and it becomes a problem on bond, I'm going to address it for you, and I promise you're not to like the way that I do it. Do you understand?
Yes, sir.
You are not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you like crazy to ensure that you're not using. Any prior DWIs, and does he have a license, please?
Judge, I don't have any prior DWIs, and I'm checking the license right this second.
If you do not have liability insurance and a Texas driver license, you're not allowed to drive, and that is also a condition of your bond.
Judge, we have that his license is eligible.
Okay. Do you have the ability to hire a lawyer, Mr. Ramirez? Do you work? How old are you, sir? Okay. We're going to give you time to hire a lawyer, so I'll have you go to Victoria, sign a reset, and then I'm going to have you take your seat in the jury box while we get your bond conditions. A, don't use. Do you understand? You're going to get called to tested. If you fail to appear, I'm going to issue a warrant for your arrest. You understand? All right.
Hello, sir.
Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present.
Here's the curveball people always miss. Smell alone doesn't equal probable cause. Odor means nothing without behavior, field sobriety tests, and chemical results stacking on top of it. That's how a real case gets built. Here's the legal gut punch. A strong blast of alcohol by itself can't convict anyone. Makes you wonder how many DWI cases live or die on details this small, doesn't it?
If you're not afford one will be appointed to you.
Thank you, Your Honor. On April 17, 2025, in Harris County, Texas, officers were dispatched to an assault call. Officers arrived and spoke with the complaining witness, who stated her and the defendant are neighbors. The complaining witness stated the altercation was only verbal until the complaining witness exited her apartment unit and observed the defendant approach her while calling her names. The complaining witness states that the defendant then struck her 3 times on the head with a closed fist. The complaining witness stated a witness was able to separate them. The complaining witness exited her apartment unit approximately 1 hour later, at which point the defendant approached her again while stating that when the defendant was in jail, she heard the CW was talking bad about her. The complaining witness stated that the defendant then struck her on the face and head with a closed fist 5 to 6 more times. The witness stated he observed the defendant pulling the complaining witness's hair, but did not witness any striking or punches thrown. The officer observed a light red mark on the complaining witness's cheek.
Any alcohol?
Take a closer look here.
Ms. Simmons, I'm going to find that there's sufficient probable cause to go forward with the case. I'm going to tell you now that I will do everything in my power to protect my community at all costs. I don't know what kind of resources you have here, but if you don't have anyone to pony up $5,000 to $10,000 if I revoke your bond, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
I don't want you to consume alcohol or illegal drugs, and I don't want you to have contact with the complaining witness in this case. I don't want you to go within 500 feet of where she lives or where she works. You understand?
We live right across the hall from each other.
Don't want you to go anywhere near her. I don't want her to be in fear when she's trying to go home.
I understand.
Actions have consequences, and I don't want you to go anywhere near where she lives or where she works. You're also not going to possess your weapons as well.
Judge, after taking a closer look, it doesn't specify whether or not alcohol played a role in this event.
Do you have the ability to hire a lawyer, ma'am?
No, I don't. I need one.
Okay. I'll give you an application. We'll see whether you qualify. I need to know everything about you, how much money you have coming in, where from, cars, anything, money in the bank, and then we'll take a look to see whether you qualify.
All right, thank you.
Brandon's going to give an application. You will meet with pre-chop for your bond conditions, then we'll have you meet with someone shortly.
Okay,
Mr. Walker, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 20th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a report of erratic driving in a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour and a 65 mile per hour.
Hey, don't talk. Don't talk. Can you start from the beginning, please?
Yes, Your Honor. On April 20th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a report of erratic driving of a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour in a 65 miles per hour zone and saw the vehicle almost strike a delineator pole. The law enforcement officer initiated a traffic stop and made contact with the defendant. The law enforcement officer observed a strong odor of an alcoholic beverage, slurred speech, red glossy eyes, swaying, and unbalance from the defendant. The defendant admitted to having 2 beers prior to driving, or 2 alcoholic beverages unspecified prior to driving. Standard field sobriety tests were conducted, a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The law enforcement officer found an open container of an alcoholic beverage on the passenger side floorboards, cold to the touch. The defendant consented to breath and blew a .137 and a .127.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your ability to drive. You are not allowed to drive. Do you understand? You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because it's a second offense, I'm requiring you now to get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If I find that you do, I will put you in jail. No more PR bonds for you. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. Does he have a license? Can you run it?
Yes, Your Honor.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear it does that you're not going to drive. I'm going to get you to Victoria where we will have you sign a reset. You will then get with pre-chop for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer. Please.
Judge,
Oh, hold on, Vic. Let me tell Mr. Walker one more thing. Come up. I am placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. I'm sending notice to DPS in Austin so that every single officer in the state knows that if you're in a vehicle driving, that vehicle is supposed to have an interlock on it. If you're caught and you don't have one, they will take you to jail. As it stands now, as part of your bond conditions, I'm warning you not to drive for the time being. Do you understand?
I got one.
Look, it's not, no response is required. I'm just telling you what the expectations are. And if you violate these conditions of bond, I will revoke the bond and I'm going to put you in jail.
I know, I was trying to get it real, but I understand, that's why I want to ask the question.
You need a lawyer. I don't want you to ask something. I don't want you to say something that hurts your case. We're going to give you time, please. All right. Good morning, Ms. Arena.
Hello, how are you today?
we took you into custody, or we have you in custody now because you are on deferred for an aggravated assault of a family member. And a motion, I'm assuming a motion, let me make sure. Yeah, it looks like a motion to revoke has been filed, and you are at a bond denied status now, meaning that you're being held at no bond. So what we're gonna do is we're gonna do probable cause in this case here. We have to take you into custody. You will probably populate on Monday's docket for the felony court.
That's for what?
You're now charged with driving while intoxicated.
Now, see, here's the thing.
Oh, did I ask you to say anything?
No, sir.
Okay, please. You have the right to remain silent.
Mhm.
Exercise that right. You
Yes,
may
sir.
say something that hurts your case unknowingly when you're trying to think that you're helping. Just don't.
Yes,
We're
sir.
going to do probable cause. Like I said, you have the right to remain silent. Anything you say.
This isn't a game anymore. He's not just a repeat offender. The court is now digitally tracking his drinking in real time. An ignition interlock is a straight-up electronic leash. Blow alcohol, turn the key, go straight to jail. No excuses, no gray area. So let me ask you, do you trust technology to police behavior like this? Or is this straight-up government overreach?
A cannon will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I'm going to appoint you a lawyer after we do probable cause to you. You can speak to someone here momentarily. Okay. So let's just do this real quick and then. Okay.
Thank you, Your Honor. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on.
Start from the beginning, please.
Yes, Your Honor. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on. The officer observed a male asleep behind the wheel in the driver's seat. The officer contacted the defendant and observed him to have red, glossy eyes and a strong odor of alcoholic beverage emitting from his breath and his person. The defendant initially refused to obey verbal commands to exit the vehicle. The defendant then exited the vehicle and stated that he would not allow any deputies to detain him and would not perform standard field sobriety tests. The officer took the defendant into custody. The officer notes that the ADA accepted charges under no refusal and that a specimen was not needed.
Did anyone see him drive? He's sitting at a pump, he's sleeping. I mean, the officer tried to go look at camera footage to see if they see him driving at all. Does anyone have him driving?
Judge, we do have camera footage from the Exxon recording the defendant driving into the gas station on the DIM summary. Yes, Judge.
All I'm asking is, do you have something that shows him driving? Okay. Mr. Rain, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well.
Yes,
You
sir.
understand? Just don't use alcohol or illegal drugs.
I completely understand.
Okay. Hold on. Does he have a valid license? Can you check, please?
Yes, Your Honor. I will check.
As long as you have a and then does he have any prior DUIs, I guess, as well?
There's no prior DWIs.
Okay. License.
And the license status should be ready for my review. Pulling up. It is. Trying to load up. It says it's eligible, Your Honor.
Great. Before you say something, let me please give you a lawyer and let me have you talk to the lawyer. And then whatever issue you may have, they can come back and talk to me. I just don't want you to say something that hurts your case in any way. I'm trying to help you, I promise.
You
Yeah,
understand?
just don't. So go ahead, put him back. We'll give him a lawyer, but don't send him down because are you ready for conditions?
Okay.
Okay, take your time. No rush. Okay.